This revision petition under Article 227 of the Constitution of India is directed against the order dated 0809-2007 rendered by the Court of Civil Judge Senior Division Sangrur wide, which the application under Order 39 Rule 1 and 2 read with Section 151 of the Civil Procedure Code filed by the applicant plaintiff was dismissed, and the judgment dated 22/9/2008 rendered by the Court of Additional District Judge Sangrur wide, which it directed the parties to maintain status quo. The plaintiff had filed a suit for permanent injunction on the ground that he had purchased the plot in dispute wide sale deed dated 30/4/1990 and came into exclusive possession thereof in the capacity of owner. It was stated that the defendants respondents wanted to take forcibly possession thereof. They were many a time asked not to do so, but to no avail. On their final refusal to desist from their nefarious designs, left with no other alternative, a suit for permanent injunction was filed along with the plaintiff an application under Order 39 Rule 1 and 2 read with Section 151 of the Civil Procedure Code seeking ad interim injunction was filed. The defendants respondents but in appearance and filed written statement and reply stating therein that they had purchased 124 square yards of the property and were in possession of the same. It was denied that the plaintiff applicant was in possession of the property in question. The remaining averments were denied being wrong. After hearing the counsel for the parties and on going through the record, the trial court dismissed the application for ad interim injunction feeling aggrieved, and appeal was preferred by the plaintiff applicant. Herein the parties were directed to maintain status quo by the Court of Additional District Judge Sangrur wide judgment dated 22/9/2008. Still feeling dissatisfied, the instant revision petition has been filed by the revision petitioners defendants. I have heard the counsel for the parties and have gone through the record of the case carefully. The appellate court came to the conclusion that the parties purchased the agriculture land comprising Khasra numbers, which was still joint. The said land had not been partitioned by the co-sharers. Under these circumstances, even if the plaintiff and the defendants purchased the property by specific Khasra numbers and boundaries, it could not be said that they were in exclusive possession of any portion of the joint property. In my considered opinion, the appellate court was right in directing the parties to maintain status quo with regard to the possession and alienation of the sued property in any manner till the same was partitioned. The judgment rendered by the appellate court therefore does not suffer from any illegality, material irregularity, or perversity warranting the interference of this court in its revisional jurisdiction under Article 227 of the Constitution of India. The same is liable to be upheld. For the reasons recorded above, the revision petition is dismissed. Stop.